Good afternoon, everyone present at this virtual mode. Myself, Mirza Junaid Beg, Assistant Professor on behalf of Faculty of Law, feels immense pleasure to welcome our resource person of the day, Professor P. Lisa Lukose, ma'am, for the FDP on emerging trends of administration of criminal justice and forensic science. Professor Dr. Lisa P. Lukose, ma'am, is currently Director, Legal Aid and Professor of Law in University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Delhi. She is first rank holder and got a gold medalist from University of Pune. She has received many accolades, including Rashtrapati Award for Guides, INSO International Research Award 2023, Leading Educationalist of India Award 2022, Dr. Sarvapalli Radhakrishnan Distinguished Professor Award 2021 in Intellectual Property Rights Law, Viva International Award 2021 for Outstanding Women Researcher in Law, and Outstanding Faculty of the Year Award 2021 for Excellence in Professional Education, and Global Faculty Award 2020 for Extraordinary Teaching Acumen, Unstoppable Educators Spirit, Remarkable Professional Skills and Contribution in the Field of Education. She is nominated by Higher Education Department, Government of Delhi as expert member in the conceptualization and formation of new Law State University in 2021. She is a member secretary to Common Law Reform Commission 2018 onwards and secretary Commonwealth Legal Education Association. She is expert member of geographical indication to advise government on matter on geographical indications. She has been expert member of, to review Geographical Indication Act of for Government of India. She has been expert legal member nominated by Government of Kerala to review police manual, and her notable publications include 9 books with international publishers and more than 70 research articles on various legal issues in reputed national and international journals. She is the member of statutory bodies in government universities. Dr. Lukose, ma'am, is a regular resource person for UGC program and faculty development program being organized by various departments of Government of India and several central and state universities. She is the principal investigator and chief coordinator of the ongoing project on common law, comparative constitution, and public law. Now the house is open for you, ma'am. Ma'am, please enlighten us with your words of wisdom on the topic eroding pillars of justice, liberty, equality, and dignity, an era of unbridled crimes. Thank you, ma'am. Please come.
Thank you so much, Dr. Mr. Janaki, for that generous and elaborative introduction. I'm really grateful. And my thanks are due to Integral University and especially Dr. Seema Siddiqui, head of the department, for inviting me here. I'm really grateful that you have given me this opportunity. Let me also congratulate the Integral University for organizing this important program and also on such important topic. Let me check once again. Am I audible and visible?
Yes, ma'am.
So that I can, yeah.
Yeah.
So the topic given to me today is the eroding pillars of justice, liberty, equality, and dignity, an era of unbridled crime. This is quite interesting and fascinating topic. When we talk about justice, liberty, equality, and dignity, we may think that it is an often beaten track, but that is not the case. The concepts of justice, liberty, equality, and dignity are as important, and these are dynamic concepts. And it is every day this can be treated as a fresh topic which encounters for a fresh discussion, deliberation, and interpretation. Dear friends, these words that are the most important words that you can find in the title itself, justice, liberty, equality, and dignity. They represent the basic values of any democratic political system, including that of our great nation. The constitutional ideas of justice, liberty, equality, and dignity has been enshrined primarily and principally under the preamble of our Constitution, though the thread can be seen throughout the Constitution. So, this is one of the fundamental and most important constitutional principle. Of course, ours is not the first constitution that thought about it and incorporated these enshrining principles. The UDHR, which was which got drafted simultaneously with that of our constitution, because we have the UDHR in the year 1948, so simultaneously both documents were drafted. So even in the UDHR and the entire International Bill of Human Rights also. And to that matter, even from the Magna Carta onwards, you can find that the principles of justice, liberty, equality, and dignity, these were the enshrining principles in every human right discourse and constitutional right or fundamental right discourse. So liberty, equality, and justice together make the democratic values without which the very individual freedom, the basic human rights, and even the self-respect are meaningless. There is an intimate or inseparable relation between these values, as you can find. But of course, these are not watertight compartments. They are interdependent and they are interrelated. The realization of one is important for the realization and achievement of the other. The invasion to one by any authority or any organization is an infringement and a compromise of the other. So that's why we treat them as well related, interconnected, and interdependent. Friends, as you know, the primary goal of the Indian Constitution is to foster harmony across the country and to make progress happen, the happiness and the economic development happen. So the factors that help in achieving these objectives, the individual liberty, individual happiness, self-respect, the dignity, the political, social, economic, and economical growth of the nation. These objectives are justice, equality, liberty, and fraternity, assuring the dignity of the individual and unity and integrity of the nation. Now, let us see this concept one by one, and then we will move to what are the new developments and the contemporary developments that we find in our nation. Let us begin from justice itself. As we know, justice is necessary to maintain order in society, which is promised through various provisions of fundamental rights and directive principles of state policy. We know the difference between this society and a crowd. A crowd or mob, it can random happen at any time. It doesn't have the social consciousness. They do not have any willingness or any promise to abide by the rules and regulations. They don't have any common aim or the common objectives to achieve. But what makes a crowd or a mob different from that of a society? As I told you, if you can call the spirit or the consciousness of the society. And when we consider the India as a society, India as a nation, actually the consciousness of the society, the spirit of the society, we derive from the very notion of so-called justice. So it comprises three elements, which are social, economic, and political, as we could gather from the preamble. Social justice means that the Constitution wants to create society without discrimination of any ground, like caste, creed, gender, religion, etc. So though the Constitution was written and got adopted in 1950s, now in 2023, when we revisit the basic principles of justice without giving any modern interpretation, but going by the very fundamental and even limited constitutional interpretation, we can see that when we correlate the concept of a society without discrimination on the grounds of caste, creed, gender, or religion, friends, I request all of you to revisit this concept and you have to correlate and resonate to the development and the incidents that are happening in India nowadays. Now, moving on to economic justice, wherein the Constitution stipulates that no discrimination can be caused by people on the basis of their wealth, income, or economic status. Political justice, the third leg of the concept of justice, wherein all people have an equal, free, and fair right without any discrimination to participate in political opportunities. As I told you, it's not only in preamble we can find these fundamental principles, but it is a thread that you can find throughout the Constitution. A couple of articles I can present it before you, which should be read along with the preamble in order to understand the width, the breadth, and the diversity of this concept. So the very first article that takes part in the golden triangle of the fundamental rights, the Article 14 of the Constitution, which promises and which also declares that the state shall not deny to any person equality before the law and the equal protection of law. Section Article 38(1), again, wherein it is ensured that the state shall secure a social order for the promotion of the welfare of the people. The state shall strive to promote the welfare of the people by securing and protecting a social order in which justice, social, economic, and political shall inform all the institutions of the national life. So, in all institutions of the national life, this is very important that the social, economic, political justice is being carried, is being implemented, and every action, every direction, every policy, every decision of the authority should have the aim of welfare of the people in order to bring a social order wherein justice is predominant. Article 39A further, where it guarantees each individual the ability to receive free legal assistance. But you can see it's very important that there are many decisions where the court has said that right to life itself includes right to have a speedy trial and right to have a accessibility to legal justice. But whether everyone in India can afford legal justice now, from the lower courts to the higher courts, in different states, in different segments of the society, how the justice is denied and how the justice is made unaccessible. And where justice is accessible, the delayed justice happening, and how the delayed justice is also preventing the justice. Moving further to Article 46, which provides that the state shall promote special care, the education and economic interests of the weaker sections of the people, and in particular of the scheduled caste and the scheduled tribes, and should protect them from social injustice and all forms of exploitation. Even with reservation, and so many judgments from the court also supporting reservation and giving hand-holding to the weaker sections of the society. Now also we can see that even after so many decades of independence and reserving a provision for reservation in the very constitution itself, the so-called social order wherein equality and justice prevails to all weaker sections, it is said to happen. It remains again as a distant dream to happen in India. Now moving to Article 142(1), which provides that the Supreme Court in the exercise of its jurisdiction may pass such a decree or make such order as is necessary for doing complete justice. So whether the courts are active, though sometimes they may be criticized for judicial activism, but whether the Supreme Court as an institution and the custodians in the Supreme Court, every single judge in the Supreme Court, as custodian of this particular vested duty that the Constitution invests in them, whether at every time they have rose up to the situation to make suo motu cases and to ensure complete justice, not only to the parties who are right in front of them in a particular case, but to the entire citizens of the country. The Apex Court, as it was held in Kesavanand Bharati case, wherein the social justice is a part of the basic structure of the Indian Constitution. So I think though Kesavanand Bharati's case is oft-quoted and it is a landmark judgment. And many other points we discuss as basic structure of the Constitution. Whether this particular point, that is social justice basic structure of Constitution, whether it is given the due importance that it deserves. So I feel most of the time this particular aspect is given no clear importance, and the policies and the schemes that the government makes sometimes forget to ensure this part of the judgment, that the social justice has to be attained in every single schemes and policies and every decision that the government takes. And again, when we move to S.R. Bombay v. Union of India case, though the Apex Court has held that social justice and judicial review are two basic features of Indian Constitution, as we have told you, it's not the dearth of judicial decision or the dearth of constitutional provision or the dearth of specific legislation. But while implementing and executing the law, so we fail to ensure that the social justice to every segment of the society, every section of the society, and every single individual of the society. Now, when we move to the next pillar, that is equality, wherein the Constitution ensures to see that no section of the society has any special privileges, and all the people have been given equal opportunities for everything without any discrimination. So the right to equality and non-discrimination, a fundamental component of international human rights law, which is very well enshrined in UDHR, ICCPR, ICESR, and the other dozens of international treaties, conventions, covenants, and protocols. As I told you, it's not the dearth of law, not the scarcity of literature available on it. And again, it is one of the 6 fundamental rights under the Indian Constitution. But to what extent we could ensure equality? We always believe and we always proclaim that our society is based on the principle of rule of law. So when a society is based on the rule of law and no man is above the law and all should be treated equally, whether that is actually happening in the country. So as I told you, you can very well correlate it from the very Article 7 of the UDHR itself than every single instrument in the International Bill of Human Rights. Again, Article 14 on which we had our small discussion now with respect to justice also. Again, that article can also very well be quoted here or rightly be quoted here because that is the beginning point of any discussion on right to equality. And we can say that even from where the very concept we borrowed, the Constitution of the United States of America, the Section 4 of the 14th Amendment to the American Constitution states that no person shall be denied equal protection of law by any state within its jurisdiction. But whether we have borrowed it from US, but the implications and the implementation of this article, whether we are doing it with the same spirit and the vigor. So Justice Bhagavati in Maneka Gandhi v. Union of India stated that equality is a dynamic concept that cannot be limited to a traditional understanding and knowledge. And this is very important, though this has happened in 1978. And when we revisit the 1978 case in 2023, whether we have understood in its proper spirit the dynamism involved in the concept of equality, and are we still erring ourselves by limiting the interpretation of equality to the traditional understanding and knowledge? I think this is a high time, and this a very selection of the topics by the university itself is a opportunity to revisit the very dynamic concept of justice and to relate and resonate with the developments that is happening around us. Apart from Article 14, there are again an array of articles that have to be read in order to understand the real connotation and meaning of Article 15. Article 15 that discriminates and prohibits discrimination in any manner, and which tries to secure that citizens from every sort of discrimination by the state, again on any ground. Along with Article 15, we have to see Article 16, which gives equal employment opportunities. but whether that is actually happening, and whether the private employment places are giving a friendly atmosphere to the employees, a favorable conditions to the employees, a favorable economic condition wherein they can be at par with the government, those who are in government jobs in terms of their salaries, in terms of their service conditions, and in terms of their other allowances. And though we say that Article 17 prohibits untouchability, and to a large extent we could bring legislations and we could reach that particular stage, but at the same time, there are many cases that go unreported, especially when it happens with the minorities and the weaker sections of the society. Moving further to Article 38(2), which provides that the state shall in particular try to minimize the inequalities in income. This is very important. The state has to strive to minimize inequalities in income. Of course, the government has done a lot of things, especially our Prime Minister Ji also made a lot of initiatives in the last 1 decade in order to minimize the inequalities in income, and to eliminate the inequality in status. But we know that we have many miles to go now, and it is again a far-fetched dream, because we have to implement the policies and the schemes and even the financial regulations that we have in proper spirit, and the lacunas we have to identify, and then we have to overcome them. Then only the true spirit of Article 38(2) can be really be achieved. And it is, and when you read thoroughly the Article 38(2), very specifically the Constitution mandates that this elimination of inequalities is not only among the individuals, but also among groups of people residing in different areas or engaged in different vocations. So we can say that really we need to devise the strategies, the mechanism, the tools, the means, and the methods by which this inequality can be eliminated, and we can minimize in the inequalities in income that we are finding in such a divided society. Article 39 and Article 42, all this can be quoted in any discussion that is emanating from right to equality, which we started from Article 14 of the Constitution. And not only this constitutional provision highlights the equality concept as one of the fundamental constitutional principles and the ideas of the constitutional principles. In order to achieve that, the government has brought a plethora of legislation. So a quick visit to a few important legislation in order to give a comprehensive outlook to this session. So you may recall the Equal Remuneration Act, the Criminal Law Amendment Act 2013, which is very important to cite in this section, especially when it is touching upon the criminal justice system, the administration of criminal justice system, which has incorporated new offences such as acts that tag sexual harassment, voyeurism, and stalking. Wherein again, in a highly patriarchal society, we are trying to emancipate and empower women, and to do justice to women by facilitating her equal participation in the society, and reducing and eliminating the chances of attacks against her by creating fear. Even we can say that prohibitions and creating fear in the mind of the people who has any plan, even by mistake, to do such a crime. Even the 2018 Amendment Act, which was enacted to provide enhanced punishment for rape and ensure that death penalty for those who are convicted for rape in a girl below 16 to in between 16 to 12 years. Though Vishaka case happened way back in 1992, the importance of Vishaka case is still in limelight. You know that from from 1992 to 2013, we had to, as a country, we had to wait for legislations to take birth. Though till that time, Vishaka guidelines formed the basis of the law. But once it had come into it had come into existence, and post committees have been constituted. You know that in every, especially for the working women, and the very definition of the workplace, if you see, it's you can say that very elaborate definition of the workplace is being given. And even with such a legislation, which is so elaborative, and wide definitions on the workplace, sexual harassment, everything is given. Post committees, internal complaint committees are being constituted, even without external members, in order to again ensure the objectivity of the provision. But despite that, also we know that we could not actually reduce or eliminate the harassment at the workplace, especially for women. And even that is with the working class. Even with the working class, those are supposed to be educated, sophisticated, and informed. If such things are happening with those category of people, then we can, as I told you, there are many crimes that go unreported for many reasons. And when we say that we want to show that India is a promising country, we are growing socially, politically, and economically. So the status of women in every country is very important, because it is the status of a woman in the country that gives nation the status. But of course, that enactment deserves a special attention as a way forward to achieve the equality. Now the rest is with the implementing authorities, because even the post committees are only recommending power to recommend. The power to implement the recommendation, that is left to the discretion of the authorities. You may also recall the Hindu Succession Act 1956 and the amendment made in 2005, leading to the removal of discriminatory provisions, wherein the females are granted ownership of all property acquired either before or after signing of the act, abolishing their limited owner status. Because I personally I believe that the economic status matters, and economic stability and economic equality is very important in order to even claim social equality and political equality. The 2017 Amendment Act made to the Maternity Benefit in 1967 also deserves to be mentioned at this juncture. But one thing that disturbs me here is that we had made studies, empirical studies, with respect to the implementation of Maternity Benefits Act. Because why I am mentioning this particular act with so much emphasis is that it's very important that you facilitate women with the necessary necessary leave, so that the childhood, the pregnancy period, and the early childhood can be taken special care. It is the duty of the mother. But though from 12 weeks to 26 weeks, the leave has been extended by a 2017 Act. The empirical study conducted by us shows that in more than 90% of the private institutes, this particular amendment benefits are not provided to the employees. We had concluded a study in 2022, and this is the disturbing findings that our study revealed. So this is again, we have act in place, but how we are implementing it. So the attitude of the society, the social conscience of the private employer, that matters. Another act that can be mentioned at this juncture is Special Marriage Act 1954, which provides for a special form of marriage irrespective of religion, faith, or whatever the other party believes. So this again means that we are trying to go beyond any barriers, whether it is created by any religious or any other beliefs. 1961 Dowry Prohibition Act. We can give sessions and hours together, we can talk about this. Though Dowry Prohibition Act 1961 is in place, we know that there is not even a single day wherein from every state dowry cases are being registered. Dowry deaths are being registered. Again, it is such a disturbing fact. If we go ahead with such a patriarchal attitude, if we go ahead with such a societal notion, can justice, equality, dignity, and liberty of women can be ensured? The Scheduled Caste and Scheduled Tribes Prevention Atrocities Act 1989 also deserves special mentioning, which aims to prevent the commission of offences and atrocities against members of the Scheduled Caste and Scheduled Tribes. A very important act in order to achieve the justice, the social justice in the society, especially for the weaker section. the Muslim Women Protection of Rights on Marriage Act 2019, and another important legislation which was enacted to protect the rights of married Muslim women. Transgender Persons Protection of Rights Act 2019, though the act received some criticism as well, but still it was a major step taken by the government to provide for protection of rights of transgender persons and their welfare. Because we have to set the system to move one. Once it is started moving, then of course you can keep elaborating the rights, you can make amendments, and you can still polish the system. But of course, we should congratulate the government for bringing this particular legislation in order to ensure the equal rights and bringing them to the equal rights of the transgenders and bringing them to the mainstream of the society. The Right of Persons with Disabilities Act 2016. That is also an important move from the government and an important move from the legislature as well, which aims to provide rights to disabled people and protect them from social stigmatization and discrimination. So as I told you, I can go on quoting some more legislations as well, but because of the paucity of time, I am not quoting more laws now. But it is very fortunate thing that our country has a plethora of legislation, wherein it has tried to bring specific legislation in order to bring and ensure equality and to reduce and eliminate discrimination. There are certain judicial interventions that I would like to mention. If you look at the Joseph Singh case, Joseph Singh v. Union of India, wherein the Supreme Court has struck down Section 497 of the Indian Penal Code. Though, again, there were a few criticisms from few corners, but at the same time, as you know, the section has decriminalized adultery in India. And the observations made by the court is very important. The court has observed that the wives are not the property of husbands, and husbands are not their masters. I think this observation was very much needed in a society wherein patriarchy is so deep rooted, in order to understand what should be the position, what should be the liberty that should be given to wives. So Section 497, according to the court, disposes of the women of her autonomy, dignity, and privacy. Therefore, it is violative of Article 14. And it violates the non-discrimination clause under Article 15, as the court has observed. Moving further to Navjot Singh Johar v. Union of India, wherein a 5-judge bench particularly struck down Section 377 of the Indian Penal Code, decriminalizing same-sex relations between consenting adults. Though I might be having my personal reservations on this, but at the same time, when you look at from the personal the liberty clause, you can see that the court found that Section 377 discriminate against individuals on the basis of their sexual orientation or gender identity, again violating Article 14 and 15 of the Constitution. And in this case, the court has further ruled that Section 377 violates the right to life, not only Article 14 and 15. It also violates Article 27, violating the right to life, dignity, and autonomy of personal choices under Article 21. So the Supreme Court, according to the Supreme Court, the community deserves equal rights and respect as any other individual, and the discrimination against an individual on the basis of sexual orientation is deeply offensive to the dignity and self-worth of the individual. You can also recall Lakshmi versus Union of India, where the Supreme Court has called out to issue directives and suggest ways to prevent attacks. So the court instructed the government at both levels to prohibit the unauthorized sale of assets across the nation. So this decision paved the way to enforce harsher punishments for people involved in such a heinous crime. Now, again, if you analyze the judicial intervention, the Vinay Sharma versus Rajesh Sharma case, where the Supreme Court held that daughters will have equal corresponding rights in Hindu undivided family by their birth and cannot be excluded from the inheritance irrespective of whether they were born before or amendment of 2005 Amendment Act. So friends, we can see, as I have told you, this justice and liberty in that way are closely connected. And now when we have our preliminary analysis of the further two notions, the liberty and dignity, we can further understand that this justice is important for equality, justice and equality is important for liberty, and these three things together makes a person's life dignified. So liberty, you can say that in simple terms, it means the freedom to live your life the way you want. But when I say that it is the liberty that the Constitution guarantees to one individual, it's the freedom to live our life in the way I want. But still, I understand that none of the fundamental rights, none of the constitutional principles enshrined in the Constitution is absolute. No right is absolute. Yes, these rights are restricted. The rights cannot be given unrestricted because when in a orderly social life, the personal liberty has to be compromised to a certain extent for the public welfare. So no rights in that way are unrestricted and uncontrolled. No right is absolute. These are controlled and restricted. But at the same time, when the authority interfere with your personal freedom, when I say about controlling restriction and fixation on the right, but at the same time, it can be only done with the proper authority. It can be done only with a valid law. So liberty does not mean that freedom to do anything. A person can do anything, but within the limits set by the law. So Article 19 or Article 21, the various interpretation given to Article 21, all this can be read together to the liberty clause. And one aspect which that comes immediately to my mind when I look at the liberty clause is that wherein the Supreme Court of India also describes this fundamental right of liberty provided Article 21 as the heart of the fundamental right. So if the liberty clause is removed, of course you can say that then you have a constitution with no heart. So again, Article 32 is there, wherein Dr. Ambedkar himself describes it as the soul of the constitution. So the right specifically mention that the chief goal of Article 22 is that when the right to life or liberty of a person is taken away by the state, it should be only according to the due process. And I am sure that the enlightened audience who hear me, you also might have made a lot of reading on the interpretation of Article 21 and the interpretation of the liberty clause in Article 21. But at the same time, let us also look into some case laws that cannot escape any discussion on Article 21 and the liberty clause. So friends, you know that though in a A.K. Gopalan case with the state of Madras, the court had to take a narrow view. Of course, you have Maneka Gandhi v. Union of India, where the court has said that the idea of personal liberty in Article 21 has a wide scope, including many rights, some of which are embodied in Article 90. And I brought this Maneka Gandhi's case here, though I know that again it is everybody quotes this, and you also might have made so much reading into Maneka Gandhi v. Union of India case. But the court very specifically addressed an issue here with reference to Article 19 vis-a-vis Article 21, and the court has very specifically mentioned that Article 19 and Article 21 are not watertight compartments. Of course, the court said that some of the rights are embodied under Article 91 are given additional protection, but it does not mean that Article 21 is given less protection. You can see that even in Francis Caroli case, wherein the court Francis Caroli v. Union of India, Union Territory of Delhi, wherein the Supreme Court has held that the right to life is not mere animal existence, and the court said that it includes the right to live with dignity. Friends, that's why I have told you. These are not watertight compartments, and the enjoyment of one is important for the enjoyment of others. And once you abolish or restrict, or once you transgress or evade on one of these rights out of these four pillars, it is invasion, infringement, and abuse of all the other three rights. You can also see that in Vellore Citizens Welfare Forum with Union of India, the Supreme Court held that though the industries are vital for the country's development, having regard to the pollution caused by them, The principle of sustainable development has to be adopted as a balancing concept. Now, again, we say that sustainable development is a beaten track, but you know that it's evolving concept. It's a ever evolving concept, and especially with the United Nations attempts to give importance to SDGs also. You can see that in India, every day we need to revisit the sustainable development concept, because always you can find a tension between development versus right to life. Development versus right to life with dignity. Let me also go to Reliance Petrochemicals Limited versus Properties of Indian Express newspaper, where it was held that the right to know falls under Article 21 of the Indian Constitution as an essential ingredient of participatory democracy. Of course, we know that when we talk about participatory democracy, without proper information, we cannot even criticize governmental decisions, we cannot take part in any deliberations, we cannot be informed citizens who can actually decide whether something is right or wrong. You can also, the old cases, Sul Batra versus Delhi administration or Husinara Khatun versus State of Bihar cases 1 and 2, this all we can recall at this moment, wherein the court has also said that it's not only for the free people in the society, these rights are guaranteed, but even for the under trial prisoners, those who are in custody, they all will be having this inalienable right, including the right to speedy trial. But of course, the right to liberty of an under trial should always be different from a free man who is not behind the bar. But still, even if a person is under trial person or behind the bar, it doesn't mean that his liberty is absolutely curtailed. Kerala Union Working Journalists versus Union of India. That case, which is a recent case, that is also very important in our discussion, because in this petition seeking the release of Kerala journalist Siddiq Kaplan, wherein the court has held that fundamental right to life is available to under trials as well. And Sujitra Srivastava versus Chandigarh administration, wherein Supreme Court has clearly held that the woman's right to make a reproductive choice also will fall under the dimension of personal liberty as understood by Article 21. There is a plethora of judgments on right to privacy, as we can read from all the cases till the Putusami versus Union of India case. And you also have Arniva Chandra versus Union of India case, wherein the court also said that the passive euthanasia can be allowed under exceptional circumstances under the strict monitoring of the court. You also have Shakti Vahini versus Union of India case, wherein the petitioner approached the upper court seeking directions to the state government and the central government to take preventive steps to combat honor crime, and wherein the court has held that the right to choose a life partner is also a conformity of Article 21. And as in the initial status of my discussion, as I have told you, so it's not only the Indian Constitution enshrines this principle in various articles, and we have a vibrant and dynamic Supreme Court, where at many point of times it has intervened and it has upheld the right to dignity, right to equality, right to liberty and justice, and where it has tried to give a harmonious construction and harmonious interpretation of this concept, where it forms the very basic structure, including the social justice. It has held that it forms the basic structure of the Constitution. This is the same way the developments and the movement that we find around the globe in various countries, including the international developments that are taking place in the human rights body. You may look at the European Convention of Human Rights, you may look at the American Convention of Human Rights, you may look at the African Charter on Human Rights, as the case may be, even the Arab Charter on Human Rights, and the Asian Human Rights Declaration, the Commonwealth Independent States Convention on Human Rights and Fundamental Freedoms. All this will echo the same principle, that there has to be harmonious construction, and for any society to progress and prosper, the protection of these rights, upholding of these rights, manifestation and enforcement of these rights is very much needed. Because when there is justice, when there is liberty, and when there is equality, that system only will lead to dignity and fraternity. The Constitution categorizes one of its objectives as fraternity, assuring dignity of the individual and the unity and integrity of the nation, as the very preamble itself. Any plain reading to the preamble itself, a literal interpretation of the preamble itself shows that. So the feeling of brotherhood and an emotional attachment with the country, that is very important. But somehow it's such an unpleasant situation that somewhere now we are missing the feeling of brotherhood. So the feeling of brotherhood, irrespective of the caste and creed, irrespective of the titles and positions in the society, is very important. And the emotional attachment with the country, which is the most important thing that we have to every time remember. And that might be one of the reasons why Article 51 was inserted by 42nd Amendment, by way of 42nd Amendment in 1976, referring to the duty of the citizen, wherein explicitly it was mentioned to promote harmony and the spirit of common brotherhood amongst the people of India. So we need to resonate and we need to correlate the Article 51 that talks about fundamental duties to the preamble itself. And we also have judgments wherein the court has said that when a person tries to enforce his fundamental rights, it's always justifiable to see that whether the person is abiding by Article 51A, the fundamental duties that a citizen owes to the country. So many of the times we find that the organization, the NGOs, and at individual level, we are overwhelming to enforce our fundamental rights. But whether the same spirit and overwhelming we are expressing to discharge our duties, the fundamental duties towards the country and towards our fellow beings that we find in the country. So in a democratic system, which would function in a healthy manner, in a healthy manner, the democratic system should function. Then only there will be a spirit of brotherhood, oneness among the people of the land. India being a land of immense diversity, it's very important that the spirit of unity and the brotherhood is very much needed. When we look at the happenings and the incidents, unpleasant incidents in other parts of India that is happening, so we understand that the feeling of oneness and the feeling of brotherhood is missing. But it's a very dangerous situation. As a nation, we have to stand together, and we should not allow any individual or any segment of the society also to play with the oneness, the feeling of oneness, and the feeling of brotherhood that we, the people of India, should firmly hold among ourselves. So the principle of common citizenship is directed towards strengthening the sense of unity and integrity. So the fraternity cannot be achieved as an isolated ideal. So when there is sense of brotherhood, when there is sense of unity and integrity, then only the fraternity can be promoted by ensuring equal rights to all. Let me quote Dr. Ambedkar at this moment, wherein he said that this is the principle which gives unity and solidarity to the social life. So fraternity is that much important. But usually in any discourse, any constitutional discourse or any discourse on human rights, fundamental rights or constitutional rights also, the fraternity is given less important. But look at what Ambedkar says. This is the principle of fraternity gives the unity and solidarity to the social life. So fraternity is not possible unless the dignity of each individual is preserved and respected. So from this you can understand what is the interrelationship between fraternity and dignity. So it's only by respecting the dignity of each and every individual, the fraternity of the nation as a whole, the fraternity of the society as a whole can be achieved. Article 39.5, Article 42, all these articles can be read together in order to understand that how this interpretation of justice, liberty, and equality should end with the discussions on right to dignity. So let me quote Francis Caroli, Union Territory of Delhi case, wherein the court rightly said, the right to live includes the right to live with human dignity, which goes the bare necessities of life, adequate nutrition, clothing, shelter over the head, facilities for reading, writing, expressing oneself. But it is very unpleasant to say that our entire population is not having this facility. So it's only few percentage who is having all the particular dignity clause the court has defined way back in Francis Caroli vs. Union Territory of Delhi case. So as a nation, we have to work together that the last person in the country, everyone in the country should have these necessities, adequate food and adequate nutrition, clothing and shelter, facilities for reading, writing, expressing oneself and developing his personality. So we can also understand that though I have spotted many cases wherein the court has rightly intervened. Now, when we look at the important judgment, so the recent case from Supreme Court, which really reflects that the pillars of justice, liberty, equality, and dignity should not be allowed to be eroded. When you look at the certain facts of the cases, because of the paucity of the time, I don't have time to explain all the facts of the case. But if anybody is noting down, you can take you can make note of the cases which very recently in 2022, 2021, and 2020 that have happened in India, which also gives us certain disturbing facts. For example, state of Jharkhand versus Talindra Kumar Rai, 2022, if Supreme Court Online SC 1494, if anybody wants the citation aspect, which was decided by and the verdict was given by Chief Justice Chandrachud and Justice Hima Kohli. So the Supreme Court has very vehemently said that though in 2013 itself, in Lilu versus State of Haryana case, the court has said that there should be no two-finger test, which will violate the right of privacy of the women. But still, the two-finger test was being conducted. So again in 2022, the court has to say that that test should be stopped, and the test is based upon incorrect assumption that a sexually active woman cannot be raped. So nothing can be further from the truth. It is a patriarchal and sexist to suggest that a woman cannot be believed when she states that she was raped. Again, 2021, what happened in Vijay Mandal Chaudhary vs. Union of India case, which was decided by Justice A.M. Khanwalkar, Dinesh Maheshwari, and C.T. Ravi Kumar, wherein the question of the rights of ED, especially with respect to challenging the constitutional validity of the several provisions, like the Section 5, Section 8 for taking possession and attaching a property, seizure and search, power of arrest, of the provision of money laundering act was questioned and challenged before the upper court. So the court said that money laundering is one of the heinous crimes, which not only affects the social and economic fabric of the nation, but also tends to promote other heinous offences, such as terrorism and offences related to NDPS Act. So the court noted that the reserved burden of proof to receive bail was justified in order to counter the heinous crime of money laundering. This is giving a very balancing picture of the situation, because crimes like money laundering, crimes like terrorism, that has to be given dubbing, and the standard of interpretation should be totally different in such cases. And if I draw your attention to Rambabu Singh Thakur versus Sunil Arora, where the Supreme Court directed the political parties and the central level and state level to upload on their respective website the correct details concerning the pending criminal cases against the selected candidates, with the reasons why such candidates have been selected, instead of only keeping in their website the candidates with no criminal record. Anuradha Bhasan versus Union of India, a 2020 case, where the Supreme Court of India held that Section 144 of CRPC cannot be used as a tool to prevent legitimate expression of opinion, where the court further said that Section 144 CRP is not only remedial but also preventive and shall be exercised only in danger or apprehension of danger. So the democratic value should be prevailed. Right to express should be prevailed, and right to dissent should be prevailed. But on many occasions we feel whether actually we have a right to dissent. So the re-exploitation of children naufrage in state of Tamil Nadu versus Union of India case, where the Supreme Court has suo motu taken, because nowadays we feel that the judges fear to take suo motu cases. However, in this case, the judges have taken suo motu cognizance when they learned amicus curiae do the attention of the court towards two circumstances and some allegations regarding detention and torture of children in police custody in Delhi and Uttar Pradesh. Amish Devgan versus Union of India case, wherein the petitioner, who was also a journalist, caused an angry religious debate which led to the registration of at least many information reports against him. So petition in this case eventually reached Supreme Court, and they wherein you can say that this in this case came heavily on the difference between hate speech and the free speech. But the court, while considering tests regarding the reasonableness, involved the realization of limits within which the natural responses shall be included, which also includes taking into consideration the characteristics of a situation and circumstances, and if a particular group is likely to get affected. And at the same time, the society is also entitled to have certain tolerance. So I think that this is the high time wherein we have to accept, considering the diversity of the religious beliefs that we have, diversity of political opinion and social preferences that we have. So high time for us to act prudent and wise, because as we say that in order to maintain a harmonious situation in the society, we have to be tolerant. At the same time, we have to act wisely and we have to act um, prudently. So there are other cases also, but as I told you, the time was given me was 2:30 to 3:30, so I have to pause here. So in order to conclude, the traditional interpretation we just cannot ignore. So that's why I have begun my discussion from the preamble and various articles in the fundamental rights and the directive principles of state policy that we are finding. But as we know, Constitution is a organic document, and according to the when law is changing, when the society is dynamic and the society is changing, law has to be dynamic. So I feel that our courts are in the right direction, taking into consideration the changing demands of the society, the changing demands of the time, and taking care of the social needs of the society and rising up to the standard. So the independence, autonomy of the judiciary has to be upheld, and any invasion that affects the independence and autonomy of the judiciary. On the one hand, when the judiciary has to be accountable for all its decisions, they have to work without any vested interest. But at the same time, it is a duty of every citizen in the country to ensure that the judiciary is independent, so that whenever necessary, it can bring summatory action and very boldly, independently, it can take decisions, so that the constitutional principles, including the justice, dignity, liberty, and equality, is upheld at every moment, at every time.
Thank you so much, ma'am, for this informative and lucid lecture. Ma'am, we have some questions for you.
Can you just
Shall I?
these are posted or something like that?
Ma'am, there are two or three questions, like whether
No, but
the
I am asking
executive.
whether it is posted in a chat or something like that.
No, ma'am. Okay. Ma'am, whether the executive body is responsible for not implementing the concept of justice, equality, and liberty in the real sense.
See, we know that for every law there should be enforceability. And if I refer to even Chandrima Das case, Chandrima versus the chairman railway board, wherein even for a foreign citizen, we had enforced the fundamental rights, and the railway authorities were made liable, and the recovery from their salary we have made. So the compensatory jurisprudence, as I was not having too much time, I could not deliberate on all this. Even the compensatory jurisprudence that we have evolved, and the courts are very much particular that it should not go from the exchequer, from the hearing officers' salary, it can be even recovered. So when of course, the duty is not only on the judiciary. Of course, judiciary role arises when we find that somebody has brought the action to the court. But prima facie, the first liability or the primary liability to enforce these things are with the executive offices. So that's why we also have a plethora of delegated legislation, rules, regulations, and bylaws, etc. Wherein even if, for example, in university or in municipality or in every working place, the respective authorities try to ensure the social justice equality. So the primary duty definitely lies with them. As I told you, the constitution or the legislation can only give the direction. They are that letter of law, and the spirit, the blood, the flesh, and the life to these legislations and constitutional provision should be given only by authority.
Ma'am, the next question from the participant side is how much reservation system helps in providing equality among the citizens of India?
See, I think as a vice person, I should not comment too much about this because the as reservation, according to me, by personal opinion, if you see, in a country like India, wherein you can see that the people is so divided, and the needy, the poor, the underprivileged, the marginalized sections of the society is too high. Without reservation, we just cannot achieve the so-called social justice because historically these people have been sidelined on various accounts. It can be caste, it can be religion, it can be any other further interest. So historically, for generations and for decades or for centuries, the people were uh, 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 discriminated. So just by declaring that our society is a inclusive society, you just cannot do justice to them. All the injustice done to them historically has to be undone now. So there should be some affirmative protection. So when we talk about equality clause also, the affirmative protection is very much important, very much important. But in what way you will implement? That is very important. So, according to me, so it is the high time, and government is slowly moving into that direction, wherein the reservation we have to implement on the basis of their needs, on the basis of their income, because we basically want that economically they have to be improved. Because in my discussion also, I have told you that the economic status is very important. Of course, economic status without education will not make any difference. I do understand that education is important, job is important, and then you need to have a better salary. So, reservation on the basis of only the caste and trade is something that we have to revisit, and on the basis of needs and economic income, we have to do that. But when you look at this division that you find in the society, when a society is divided in this way, this is not the right time to do away with reservation. And for I cannot give a mathematical formula or a mathematical percentage, which will be the ideal. Of course, it is against the prerogative of the authorities, and from state to state it may vary, from society to society it may vary, because you have to really look into the grassroots level demands and requirements.
Ma'am, next question and the last one. Ma'am, what's your view on the Uniform Civil Code in the sense of providing equality and justice to all?
Again, this is a highly sensational question. See, I myself is a person belonging to minority, but I would always say that when there are certain religions wherein we feel that the women are unrepresented or underrepresented in such communities. Of course, the Uniform Civil Code, I find the way it is being proposed as an instrument, as a tool to bring inclusivity, as a tool, as a mechanism or a method to bring the gender parity and gender inclusiveness. I am not against that.
Thank you, ma'am. Thank you so much for coming and
Thank you
your
so much.
lecture. Yes. Okay,
And
ma'am.
this program, I really appreciate especially the topic that you have selected. This is really contemporary and very significant. So all the
Thank you
best
so much, ma'am.
for your SBT.
Thank you, ma'am. Thank you, ma'am. And good
Thank you so
afternoon, ma'am.
much. Good afternoon. Thank you so much. Thank you for coordinating with us. I can sign off.